Hello, welcome to Legally Dephine. My name is Dephine and this is Introduction to Law LB101. This is Introduction to Law, and in this lecture we are going to be defining law in general. For easier digestibility, this lecture has been divided into 3 parts which should be popping on your screen. So, as I just said, this is part A of the lecture and we are going to cover the definition of law and the theories of law. What is law? Law refers to rules and regulations that govern human conduct and other societal relations and are enforceable by the state. What makes law different from any other rules that may exist in a society? It is the quality of enforceability by the state that distinguishes law from any other rules that may exist in a society. Of course, there may be other rules that govern societal conduct. For example, moral rules, religious directives, organizational rules, and so on, which may even be more effective in ensuring compliance with a certain type of conduct. They may even be more acceptable. However, it doesn't matter whether rules are effective. It is not their goodness or badness that ensures legal quality. It only comes back to one thing. Enforceability by the state is the only factor that determines whether a rule is law or not. So, what distinguishes a legal rule from any other rules that exist in a society is that a legal rule is one that is recognized as law and is enforceable by the state. In order to understand the nature of law, let us look at the 2 theories of law, the natural law theory and the positivist theory. Under natural law, law cannot be separated from the precepts of morality, fairness, and justice. It says that a set of moral principles exists that have validity and authority independent of any human authority. These moral principles, which have a higher status than any human-made law, constitutes what is termed natural law. Therefore, any law which contradicts natural law is invalid and is no law at all. The Latin maxim lex in iusta non ex lex, which means an unjust law is no law at all, underscores the main idea of natural law theory. If you find this lecture beneficial, please hit on the like and subscribe buttons. Don't forget to click on the notification bell so you never miss on our latest lectures. Your support greatly helps us continue with our work here on Legally Dephine. Let's continue with the lecture. On the other hand, the positivist theory says that law is law regardless of its moral content and whether it is just or unjust. Therefore, there is no such thing as a good law, a bad law, an unjust law, and so on. What law is one thing, its goodness or badness is another. This theory is the prevailing doctrine in our definition of law, and almost every legal system applies this doctrine in ascertaining what the law is in any given situation. So, one must simply ascertain the applicable rule of law. What is the law? What does the law say? It being just or unjust, fair or unfair, good or bad doesn't matter. What matters is it recognized as law and enforceable by the state? If that's the case, then it is law. Now, given our definition of law, how do we determine that a rule is law and is enforceable by the state? The answer to that is very simple. For a rule to be called law and for it to be recognized and enforceable by the state, it must emanate from a recognized source. We have 4 sources of law: legislation, also called statutes, common law, custom, and authoritative texts. A rule is only a rule of law if and only if it emanates from one of these sources. We shall discuss these sources in detail in our coming lectures. Remember, the relationship between law, morality, and justice shall be the second part of our lecture Introduction to Law. If you watched the video up until the very end, thank you so much. See you on the next one.